In October of last year, Warner Brothers attempted to register the phrase, "I solemnly swear that I am up to no good" with the US Patent and Trademark Office for a variety of different products. The phrase comes from the Harry Potter book series and movie series, and Warner Brothers is the owner of the intellectual property in the movie series. The examining attorney assigned to this trademark application issued an initial denial, however, because the examiner felt that this was an informational slogan that conveyed information and was not registrable as a trademark. That examiner also found that the registration of this would create a false association with the Harry Potter book series, and particularly the book titled Harry Potter and the Prisoner of Azkaban, and would be confusing to consumers if it was registered by Warner Brothers. Now, the second issue can likely be overcome because Warner Brothers likely has an agreement with the author of the Harry Potter book series that would allow them to make these kind of filings. For example, they own Muggle for a variety of things, including clothing. And so you would assume that if she was going to object to Warner Brothers' use and registration of these phrases, that they would have done that, a long time ago. But it's this first issue that is particularly interesting because it represents a huge shift by the Patent and Trademark Office towards not allowing commonly used words or phrases to be registered as trademarks. Some examples of phrases that were found to not be protected under trademark law are the phrases "drive safely" or "proudly made in America." The examining attorney here said that "I solemnly swear that I'm up to no good" falls into this category of such widely used phrases by such a large variety of people that no one would think that any one company would produce all of the different goods or services that have used this popular phrase, or as the examining attorney said, one of the most famous quotes to come out of the Harry Potter universe. Now, this doesn't mean that you should have free reign to use any of Warner Brothers' IP assets as you wish, but it is an interesting denial, and one that I'm sure Warner Brothers is going to be fighting vigorously because of their other filings, such as something like Muggle, or any of their other Harry Potter related filings that may have widespread use by a variety of people on platforms like Etsy, Amazon, or anywhere else where these phrases might be used in a context that Warner Brothers may not want them to, but perhaps can't stop them. It's important to note that each of these situations is judged on its own merit, and that there's no one-size-fits-all approach. So if you have questions, feel free to give me a call.